Here's one of the problems I have, as I mentioned before, with the instructions on assumption of the risk is the fact that there's no definition. And there's a case from the federal court, Fashauer, F-A-S-H-A-U-E-R, 57 F3rd at 1275 is where I got the site. But it gives a definition of both the contributory negligence and assumption of the risk. And it goes like this: an employee's voluntary knowledgeable acceptance of a dangerous condition that is necessary for him to perform his duties constitutes an assumption of the risk. Contributory negligence, in contrast, is a careless act of remission on the plaintiff's part, tending to add new dangers to conditions that the employer negligently created or permitted to exist. So they draw a distinction. But the problem, as I see it, is the jury can do very little with this assumption of the risk instruction. So it's just very, very important that you educate your judge and get them to knock out that evidence, which is really assumption of the risk, where the defense is trying to use it as contrib. A couple other trial considerations. One, it's real difficult to get medical bills in these cases. The Section 55 of the FELA trying to get fancy with going on here. There we go. My problem is I didn't get my trusty friend Mike Coe involved until about a minute and a half before my presentation. They get a set-off for anything that they've paid, essentially. And the case law goes a couple of different ways, but there's a Van Holt case in the 1st District, and then there's the Varhall from the 7th Circuit. And what happens is, because these guys are working for the railroad provides them benefits. They give them health insurance. And through that, their medical bills are getting paid. And the argument from the railroad is, hey, we've already paid for part of this. And that Section 55, allows for them to have this set-off. My counter-argument to that is that's an affirmative defense that needs to be pled and proved. They need to put this evidence in, and if they haven't do it, they don't get the set-off. And in either event, it's a set-off. It's not a bar to the evidence. And so the medical bill should come in. I've had mixed success with this. I had more success. I had one case that went to trial involving it was a guy that got hurt on the job and then was being driven to the company doctor for one of his checkups and was involved in a wreck with a truck. So by virtue of the fact that the truck was involved as a third-party defendant, we were able to get him in this way and kind of avoided it. But I'm going to keep pressing the issue. And I think probably the most prudent way to do it is if I think that I might be pushing the envelope a little too much, after the verdict, I'll tell the judge, okay, yeah, give him the set-off. I've already gotten the benefit of the fact that I've got all these medical bills in that serve as an anchor for the jury to give higher damages, because that's really the whole goal, is to get some blackboard numbers in front of them. One of the things that I've spent a whole lot of time trying to learn this area of the law, and I think one of the things that I love when I go to seminars is I have something I can take away. And what I did was I put together some of the books that I use with great frequency, because I think they'd be helpful to anybody getting into this. This book right here, Train Accident Reconstruction and FEL Litigation, this is written by Bill Youngbauer, is a well-known plaintiff's FELA attorney from up in Minnesota. And Lumet he's a railroad expert. This thing's like 35 chapters long, and it covers just about everything. I mean, it probably skims over some things, but I look at this book probably twice a week. And I would encourage anybody that's taken on one case or more cases that you get this. This book on the left, this book, the first case that we handled, the first railroad case that we handled wasn't an FELA case, but we're getting into it. And I wanted to learn everything I possibly could in order to be able to talk the talk and walk the walk. And on that case, I had this expert, Jimmy Scott, he's from Tennessee. He's an old He's an old locomotive engineer from Tennessee. And I said, Jimmy, you know, how am I going to learn this stuff? He goes, this is the book, Ben. This is it right here, the railroad, what it is, what it does. And Jimmy was, I couldn't believe some of the stuff that he was telling me when we were going through this. It was a case that a guy that passed out drunk on the railroad tracks and got run over. And we actually were able to turn it into something. And one of the reasons was one of these great rules that they use on the railroad. There's a rule in the railroad that you have to, when you're operating a train within yard limits, which is a geographically defined thing, when you're operating a train within yard limits, you have to be able to bring your train to a stop within half the distance that you see the track to be clear. And I remember when Jimmy told me this, I'm like, that doesn't make any sense. How can you bring a train? These things are huge. You know, how could you bring it to a stop like that? And he goes, Ben, it's the rule. You got to remember, these rules were written in blood. And he goes on, and I love it. I try to, it's kind of crossing the line saying that in closing argument, but one day I'll get the guts up to say it. But it's true. All of these rules, somebody got killed or maimed, and then they implemented a rule, whether it's a CTA rule or an ATV rule. All of them are rules that somebody got hurt, and they put the rule into effect. And so, but Jimmy Scott, he's taught me a lot about the railroad, but it started by recommending this book. Some of these other ones, this is this car encyclopedic, car and locomotive encyclopedic. This is great for if you have mechanical department cases. And then I'm always, these are some of these, the CFRs that we use a whole lot. This one on the right has, it's most of the mechanical department rules that are going to be in effect. But it's really important to, if you're going to take on one of these cases, you got to learn. You got to go back to school and just immerse yourself in the science of the cases. One more area, and then I'm going to wrap it up. Special interrogatories. These are the bane of all our, no matter what the case is, are the bane of our existence. They can take away the best verdict, or they can just confuse the hell out of the jury to the point where they don't know what they're doing. And obviously, you know, we're the ones we're not looking to give these special interrogatories. I always take with me, every time I go out to trial, Grant Dixon wrote a wonderful article in our magazine several years ago, and it goes through kind of the whole history of all the special interrogatories and kind of where the parameters are. I have 2 cases up on appeal right now. I got both were verdicts, and both of them were cases in which there was an instruction that was submitted to the jury on their FELA duty. And the duty under the FELA, or one of the duties, is one of the many, many duties, is to provide a reasonably safe workplace. And the jury's instructed on that. It's kind of a lone instruction. Even if you're claiming they've breached a number of different duties, that's kind of the central duty. And so Metra, in both of these cases, submitted special interrogatories that, you know, did Metra operate with ordinary care and providing a reasonably safe workplace. And we objected to them in both cases as being an improper form and not going to a material question of fact. Both the trial judge at the time they were submitted and in the post-trial motions agreed with us. Now, it's a consideration you need to meet. I know other people have different thoughts on what to do with these special interrogatories, but they're dangerous from the standpoint of it's de novo review when it's taken up to the appellate court. So it's kind of a risky go at things. I think we're right. We're going to find out in the next 6 months whether we are on both of these. But it's something to keep in mind. And I have plenty of case law if anybody's considering challenging a similar one. And I suspect they're being submitted I know they're being submitted in all Metra's cases. I don't know what other railroads are doing with it, but I think they're wrong. Special interrogatories are designed just to confuse the hell out of the jury, and they're not there to help us. That's all I've got. Does anybody have any questions?